Author of a new book called The Conscience of the Constitution. The Conscience of the Constitution, subtitled The Declaration of Independence and the Right to Liberty. Timothy, are you in the Washington area, or where?
Actually, I'm out in Phoenix, Arizona today.
So good morning to you.
Thank you so much for having me on.
Tell us a little bit about yourself.
Well, I'm professionally, my job is suing the government for a living. I'm in the business of defending the rights of business owners and property owners in courts across the country. And in that, I work with the Pacific Legal Foundation, which is a nonprofit legal foundation headquartered in California, but we have offices across the country. And we specialize in defending constitutional freedom and private property rights. And in my spare time, I write on these issues for the general audience. And so I've written, this is my third book, written books on private property rights, economic freedom, and now on constitutional interpretation in general and the role that individual liberty plays in our constitutional order.
All right, your book, The Conscience of the Constitution, give us an overview.
Well, I argue that the principle of individual liberty, that we are born free, which is articulated in the Declaration of Independence.
It's also a great movie.
The conscience. It serves as the conscience that guides how we should interpret the Constitution. So, for instance, if you've seen the classic movie Pinocchio, Jiminy Cricket is the official conscience who tells Pinocchio when he's doing something right and wrong. And in a sense, the Declaration of Independence should serve as the guide for understanding our Constitution and knowing whether we're reading it the right way or the wrong way.
Well, is that generally, now I happen to agree with you. I'm not a lawyer and certainly not a constitutional expert. I do agree with you. Is that the prevailing view in terms of most of those who are in the judiciary, most of those who are political scientists and colleges and universities, law school professors? Is the Declaration of Independence given that kind of stature in, let's say, the liberal/progressive movement?
Unfortunately, no. In fact, both liberals and conservatives generally reject the idea that the Declaration of Independence should play any role in understanding the Constitution and, in fact, reject the principles that are articulated in the Declaration. What has happened is that beginning at the start of the 20th century, judges, lawyers, political philosophers, and others turned away from those principles and argued instead for the idea that democracy and not liberty should be the most important constitutional value, and that liberty is really just a permission that is given to you by the government. The government gives you freedom as a privilege, which, of course, the government can revoke when necessary for the benefit of society. And unfortunately, both conservatives and liberals have absorbed this idea, and it's become so much of a bedrock of our modern legal system that most judges and lawyers and law professors would laugh at the idea that the Declaration's principles are in any way part of our legal system.
Well, Tim, I have a hard time understanding why conservatives would buy this, and here's why I say that. You know, the Declaration of Independence says that we have we are endowed by our Creator with certain unalienable rights, among them life, liberty, and the pursuit of happiness. And it also speaks of nature, the laws of nature, and nature's God. So it seems to me, from a conservative perspective, you would argue that if our rights do not come from God, if they instead come from government, then government can take our liberty away at whim, or by power, if nothing else. So why would conservatives discard those principles found in the Declaration of Independence?
I agree. I think it's really shocking that they have done so, but it has been that way. For example, Justice Antonin Scalia has rejected the idea of relying on the Declaration of Independence to interpret the Constitution. He has said it is, quote, not part of our law. There was a case about 15 years ago in which the question was whether Washington State passed a law that said that parents were required to allow grandparents to have visitation rights with their children, even if the parents didn't want the grandparents visiting their kids. and the constitutionality of that went up to the Supreme Court. Justice Thomas, who does think that the Declaration is part of our constitutional order, said that he thought that was unconstitutional. It violated a person's fundamental right to oversee the upbringing of their children. But Justice Scalia came out on the other side, and he said he thought the law was constitutional, and he said that whatever one thinks about the Declaration, it does not control our constitutional interpretation. And Chief Justice William Rehnquist and Judge Robert Bork both agreed with that. In fact, Chief Justice Rehnquist once said that if a constitution incorporates protections for liberty, those protections take on a moral goodness only because they've been included into the Constitution by a people. In other words, anything that the people, that the majority chooses to put into the Constitution is automatically morally right. That was what Chief Justice William Rehnquist said. So I agree. It's really startling that so many conservatives have adopted these ideas, but that has been the case when it comes to judges.
Talking to Timothy Sandefur, Sandefur, the conscience of the Constitution. What does the Civil War have to do with all this?
Well, I think the Civil War, somebody once said that the Civil War is like the Iliad and the Odyssey of American civilization. If you want to understand America as a nation, you have to understand the Civil War, because so much of our political and constitutional and social institutions were at the heart of what happened in the 1860s, and especially when the war ended. When the war ended, the anti-slavery political leaders saw the opportunity to rescue the Constitution from what they thought had been the perverse interpretations that had been imposed on the Constitution by the pro-slavery forces, things like the Dred Scott decision. These anti-slavery leaders said Dred Scott was always wrong. The Constitution was, at best, only made compromises with slavery, and now is the time to rededicate our Constitution to the principles of the Declaration of Independence. And what they did in order to accomplish that was they wrote the 14th Amendment. The 14th Amendment says, it makes clear that the principles in the Declaration are now absolutely part of our constitutional system. Americans are Americans first, and only citizens of the states secondarily. That's the first thing the 14th Amendment said. Then it says, individual rights that belong to us cannot be taken away from us by the state. The state cannot take away our freedom. It can't take away due process of law. It can't treat us unequally, and so forth. That became sort of, a reconsecration of the Constitution to the principles in the Declaration of Independence. Unfortunately, as I said, at the beginning of the 20th century, a lot of that was undone by progressives who have managed to undo a lot of what the 14th Amendment was intended to accomplish.
The 14th Amendment, again, the purpose of which is what?
The 14th Amendment guarantees your federal rights against interference by states. So originally, the Constitution was kind of ambiguous. In fact, the Constitution, when it was originally written, this surprises a lot of people, but the Constitution, when it was originally written, never defined the word citizen, which is really shocking if you think about it. Any government has to be able to tell who its citizens are, but under the original Constitution, that was left undefined. So the 14th Amendment clarifies that. It starts out in the first sentence by saying all persons born or naturalized in the United States and subject to its jurisdiction are citizens of the United States, and then secondarily of your state. And then it says states cannot violate your federally protected constitutional rights. And this was a way of eliminating a decision from the 1830s or so, when the Supreme Court said that the Bill of Rights only protected you against the federal government, and states were still allowed to trample on your freedoms and treat you arbitrarily and violate your liberties. The 14th Amendment says no more.
Was it up until about the Civil War, or maybe a little bit afterwards, most people in this country identified with their state first, and then they were a U.S. citizen?
That legally speaking, that's absolutely true. In fact, before the 14th Amendment, you were a citizen of the United States only if the state said you were. So what that led to was different states had different rules for citizenship, so that a person could be a citizen of the United States if he lived in Massachusetts, but not a citizen of the United States if he lived in South Carolina, which is really shocking if you think about it. So, for example, a free black man could be a citizen of the state of Massachusetts before the Civil War, but could not be a citizen in South Carolina. And so South Carolina passed a law saying that any sailors, any black sailors on ships that landed in South Carolina had to be put into jail at the captain's expense until the ship sailed away again. And if the captain failed to pay the bill, the sailor would be sold into perpetual slavery. Now, this is really shocking because a black man could be a citizen of Massachusetts and could be a sailor on a ship, because obviously Massachusetts depends a lot on shipping, sail down to Charleston, South Carolina, and would be imprisoned until the ship left harbor and possibly sold into slavery, even though the U.S. Constitution at that time, and of course today, said that a citizen of the United States traveling from state to state is entitled to all the privileges and immunities of citizens of the United States. So a citizen could be discriminated against and even enslaved simply for traveling into another one of the United States. The 14th Amendment stops that by saying, no, if you're a citizen of the United States, then that takes precedence over whatever any state might do to you.
You
So,
agree? You agree
there was
with
a
that?
legal and a psychological attitude that states came first and that the federal government came second.
And that's one of the reasons why Robert E. Lee did not take the offer by President Lincoln to take command of the Union forces against the Confederacy, because Robert E. Lee said, "I can't kill my fellow Virginians." You know.
And he and others often referred to their home states as their country.
Yeah. Yeah. Your book is called "The Conscience of the Constitution." The Declaration of Independence and the Right to Liberty. It's available bookstores everywhere. Do you also have a website where you have for this book?
I do. You can go to my website. It's my last name, Sandefur.typepad.com, or you can go to timthelawyer.com. That's timthelawyer.com.